Hi, everybody. This is David O'Dea with O'Dea Schneider PLLC. And today we're breaking down one of the most important timing rules in the military justice system, the 120-day rule. It's not just a number, it's a line in the sand, a guarantee that the government cannot hold a service member in limbo forever, waiting for trial while their career, reputation, and future hang in the balance. The 120-day clock doesn't start by accident. It begins when the government takes real action, action that shows it intends to prosecute. That moment comes when charges are preferred, or when a service member is placed in pretrial restraint, or when a case is sent back for retrial. From that point forward, the government has 120 days to bring the case to trial, meaning the arraignment must happen before that deadline expires. It's a firm rule with a simple purpose. Justice must move forward. But not every day counts in that 120-day calculation. Some days don't belong to the clock. The law recognizes that life and litigation can get complicated. Time is excluded when the defense asks for a delay, or when the accused undergoes a mental evaluation, when appeals are pending, or when circumstances make delay unavoidable. Deployment, unavailable witnesses, acts of God. Those days don't necessarily count against the government, but it's not a free pass either. Every excluded period must be reasonable, and every delay must be justified. If the government wants to stop the clock, it must show why. Because when the clock runs out, when the 120th day comes and the government hasn't brought the case to trial, the rule speaks with absolute clarity. The charges should be dismissed. Now, that dismissal can happen in two ways, with prejudice or without. If it's without prejudice, the government can start over. They can refile the charges and begin the countdown again. But if the court says with prejudice, that's the end. The government doesn't get a second chance. Those charges are dead. So how does a court decide? It looks at the whole picture. How serious was the offense? How did the delay happen? How did it hurt the administration of justice? Did it harm the accused's ability to get a fair trial? If the delay was minor, technical, or caused by factors beyond control, the court may allow the government a second chance. But when the delay is unjustified, excessive, or shows disregard for the law, the court can end it right there. In United States versus Dooley, the Court of Appeals for the Armed Forces made that point crystal clear. Even if the accused can't show specific prejudice, even if no direct harm can be proven, a blatant, unjustified delay can still result in dismissal with prejudice simply because it undermines confidence in the military justice system itself. At the end of the day, the rule of 120 days ultimately ensures that justice is administered not only in a fair but timely manner. Thanks for watching the video.